the following reliefs. They are a declaration that the claimant is entitled to be given the disciplinary committee final report that allegedly investigated the alleged conversion of cash overage to his personal account by Jeremiah Akpan, whom the claimant reported for cash pilfering and failed integrity test. B, a declaration that there is no condition of service in the first dependent conditions of service entitling the first dependent officer to advise a party, in this case claimant, to resign his appointment with the first defendant for committing no offense and or making a proved allegation against a junior staff, Mr. Jeremiah Akpan. C, a declaration that the claimant was never found wanting by the second to seventh defendants disciplinary committee panel report and not entitled to be given document advising claimant to resign in any material particulars. A declaration that the advice to the claimant was who committed no offense and had no dent in his record to resign is not contained in the condition of service of the first defendant and is null and void and of no effect. E, a declaration that the said advice to resign is defamatory of the claimant and gives the impression that he took part in pilfering of the first defendant customers' money and derogatory of the claimant. F, an order of this court for the first defendant to bring up the report of the disciplinary committee, final's report relating to the claimant to the honorable court for purpose of being quashed. G, an order of this honorable court quashing setting aside the disciplinary committee final report as if it relates affect claimants being a nullity. H, an order of this honorable court for the payment of the sum of 24 million only being for physical pain, emotional and physiological trauma, the advice to resign which caused the claimant. I, an order of this honorable court that the claimant is staff of the first defendant and entitled to all his emolument from July 2018 to date. J, an order for payment of unpaid salaries allowances to the defendant. K, special damages in the sum of 1,800,000 for prosecution of the enforcement of the payment of entitlement via this suit. And L, general damages in the sum of 100 million naira against the defendants. Upon being served with the originating process commencing this suit, the defendant filed a joint statement of defense, and the claimant filed a reply to the joint statement of defense. The claimant, in proof of his case, testified as CW1 and tendered 14 Exhibit 1 Chijoke Asuko, called by the claimant, also testified as CW2, while the defendant in their defense called only one witness, Mr. Emmanuel Oluyori, the third defendant, who testified as DW1 and also tendered 10 exhibits. The case of the claimant was because of time, I'm going to skip reading the case of the claimant. I have also the case of the defendants. I will skip reading them. I go to the submissions of counsel for the defendants. Counsel for the defendants submitted only one issue for determination. That is to say whether the claimant has proved his case to be entitled to reliefs he is claiming. The argument in support of the issue has been captured in the body of the judgment. So I will skip reading the submissions. Then I go to the submissions of the claimant. The claimant submitted 3 issues for determination. Argument on the 3 issues have been captured in the body of the judgment. I now go straight to the decision of the court. I have carefully and painstakingly perused the processes filed by the parties, the evidence laid at the trial, the written and oral submissions of counsel for the parties. From the facts of the case, the issue calling for resolution is whether the claimant has proved his case to be entitled to judgment. The claimant has made heavy weather regarding Exhibit D8 and D11, which are same document. According to counsel for the claimant, Exhibit D8 or D11 ought to have been quashed by the court for having been secured in violation of his fundamental right to be tried before a competent criminal court or tribunal for the criminal allegation level against him before setting up of the committee that tried him for misconduct, as the advice to the claimant to resign was predicated on the allegation of conversion of overages for defrauding the first defendant of the sum of 3,950 into his personal use or those of his immediate family, and for compromise and doubtful integrity, and thereby a thief, which the first defendant rightly dismissed where the first defendant advised to resign. It was also the submissions of counsel for the claimant that the report of the disciplinary committee relied by the first defendant to advise the claimant to resign was not ready or signed as at all by the members of the said disciplinary committee, so that the advice to resign was ill-motivated to cause harm to the reputation of the claimant and paint him as a criminal. Counsel also submitted that under cross-examination of DW1, it shows that Exhibit D8 was made by a party interested at the time when the litigation was pending between the parties. By Section 83, subsection 3 of the Evidence Act, Exhibit D8 is inadmissible and ought to have been rejected by the court. Counsel further submitted that Exhibit D11 cannot be relied as well on to fine for the disciplinary committee, as same was signed by only 2 of the members of the committee. The counsel for the defendant, in response to the claimant's argument on the efficacy of Exhibit D8 and Exhibit D11, submitted that the claimant's conduct regarding financial impropriety, regarding overages, which called to question his integrity, and trustworthiness as a staff of the first defendant is act of misconduct, which falls within the domestic jurisdiction of the first defendant. It was based on that disciplinary committee was set up by the claimant, and the claimant appeared before the committee and defended himself. Exhibits D4 and D7 constitute the operational instrumentality for the first defendant to tackle or handle misconduct of his staff. Exhibit D4 and Exhibit D7 are binding on the claimant, as he never objected to their operation. It was wrong for the claimant to insist on first being tried by criminal court or tribunal before facing disciplinary action. On signing of Exhibit D11 by only 2 members of the disciplinary committee, counsel submitted that it is not in dispute. Claimant appeared before the committee and defended himself, and the said report was read to him, wherein he was advised to resign. The claimant obeyed the advice and resigned voluntarily by the Exhibit D2 without any regret and ill feeling. The claimant, having resigned and moved on with his life, the issue regarding the disciplinary committee has been overtaken by the claimant's voluntary resignation. Let me start by considering the admissibility of the report of the disciplinary committee set up to try the claimant for misconduct. Exhibit D8 and Exhibit D11, which the claimant is vehemently contesting their efficacy to close the defendant with requisite power to discipline or impose sanctions on the claimant, as provided for in Exhibit D4 and D7. It is to be noted that Exhibit D11 was the document front-loaded by the defendant as documents they want to rely on at the trial, but they failed to tender it during evidence in chief of their only witness, DW1. However, claimants confronted DW1 with Exhibit D11 under cross-examination, and it was tendered through DW1. For Exhibit D8, it was not front-loaded at all by the defendant, but it was tendered through DW1 in the course of his evidence in chief. It was admitted because the court found it to be relevant to the proceeding. The only difference between Exhibit D8 and D11 is the signatories, but the content are the same. Exhibit D8 was signed by 4 members of the disciplinary committee, while Exhibit D11 was signed by only 2 members of the disciplinary committee. This was also confirmed by DW1 under cross-examination, where he stated that the Exhibit D8 was signed when this matter is pending before the court. A careful perusal of the 2 exhibits will show that one common feature, that is to say, they were not completely executed by all the 5 members of the disciplinary committee that conducted the hearing of the disciplinary action against the defendant. This means that the 2 exhibits were incomplete. Going by the provisions of the Group HR disciplinary processes and section policy, the committee was set up under Article 20 of the said policy, and it was mandatory for all the 5 members of the committee to participate in the proceedings of the disciplinary committee. Therefore, it means the report must be by the 5 members of the committee. However, only 4 of the members have signed Exhibit D8. This means that Exhibit D8 is an incomplete document due to the absence of the 5th member of the committee who has not signed, which also goes to show that the Exhibit D8 cannot be taken to be representing the outcome of the disciplinary committee in which the 5 members of the committee were said to have conducted. In the circumstances, both Exhibit D8 and D11 have no evidential value, as they were not authenticated to invest in them the credence for which they were meant to. The counsel for the claimant has also argued that Exhibit D8, having been signed during the pendency of this suit, as DW1 has stated under cross-examination, it is a document that was made while the litigation in this case was still pending before the court. I quite agree with the counsel that even if Exhibit D8 was not caught by incomplete execution, it will be rendered impotent due to the fact that it was executed during the pendency of this suit, thereby offending the clear and unambiguous provisions of Section 83, subsection 3 of the Evidence Act. See also the case of NSITF Management Board versus Livco Nigeria Limited, reported in 2010, Certain Nigerian Whistleblower Report, Part 1211, page 307. See also UTC Nigeria PLC versus Lawal. Citation has been provided. See also Ikechukwu versus INEC. Citation has been provided. See also NBC PLC versus Ubani. Citation has been provided. In view of my finding that Exhibit D8 and D11 have no evidential value as they are not, they, they are they are incomplete due to non-execution by all the members of the committee. They are therefore unreliable for not having been fully executed. Same are hereby discountenanced for the purposes of this judgment, as they have no evidential value. On the issue of propriety of trying the claimant before the disciplinary committee before being prosecuted before a competent criminal court or tribunal, it is well settled that, given the law as at today, an employer need not to await for conviction in a criminal allegation before determining the employment of an employee. See the cases of Arinze versus First Bank of Nigeria Limited, see Olarewaju versus Afribank Nigeria Limited, see Egbe versus NUT, see also ATA Poly versus Minor, see also UBN versus Chinyere, see also Attorney General of Kwara State versus Ojulari, see also Jibril versus Ministry Administrator of Kaduna State. By these authorities, the law is well settled that an employee can be tried and dismissed for misconduct, notwithstanding the existence of a criminal allegation against the employee. Specifically, the Supreme Court, in the case of Arinze versus First Bank of Nigeria, held that an employer can dismiss an employee where the accusation against such employee is of gross misconduct involving disobedience, involving dishonesty, bordering on criminality. And in such a case, it is not necessary nor required under Section 36 of the 1999 Constitution that an employee must first be tried in a court of law. To the court, it is therefore erroneous to contend that once crime is detected, the employer cannot discipline his employee unless he is tried and convicted first. In fact, by the decision in the Attorney General of Kwara State versus Ojulari, prosecution of an employee for misconduct before a court of law is not a sine qua non to the exercise of the power of disciplinary action by an employer. It depends on the circumstances of each case. The argument of the claimant here accordingly holds no water, and so is hereby discountenanced. The defendant has the requisite power to try and discipline his staff even on the face of criminal allegation. The grounds of the claimant is that he was forced to resign his appointment by the first defendant. What emerges from the facts and evidence before the court is that the case put forward before the court is that of constructive dismissal. The concept of constructive dismissal presupposes a situation where employee left his employer as a result of conduct of the employer. That is to say, it is the conduct of the employer that made the employee to leave service. See the decision of this court in the case of Ms. Ebere Ukoji versus Standard Alliance Life Insurance Company Limited. See also Mr. Patrick Obiora Odlim versus United Bank for Africa, suit number NICN/LA/353/2012, the judgment of which was delivered on 19th June 2014, where this court held that attempt to have the employee resign rather than outright firing of the employee means that the employer is trying to create a constructive discharge. The legal consequences of constructive dismissal is generally it leads to the employee's obligation ending and the employee acquiring the right to seek legal compensation against the employer, especially as Section 19D of the National Industrial Code permit the court to award compensation or damages in deserving circumstances. In CBN versus Aribo, constructive dismissal was described. So the Supreme Court described constructive dismissal to mean a forced or compulsory resignation by an employee amount to a forced or compulsory resignation by an employee amount to constructive dismissal associated with misconduct. See also the case of Elo Dibia versus Nigerian Cement Company Limited. See also Celcon versus Celcon Tannery Limited versus Abubakar and others. The question that need to be answered now is whether the resignation of the claimant in this case amount to constructive dismissal in law. This is because the claimant insisted that he did not voluntarily resign, as his employer, the first defendant, advised him to resign after appearing before the disciplinary committee while on suspension for 5 months, 3 months of which was spent on half salary, while the remaining 2 months was without salary. While the defendant maintained that the claimant resigned voluntarily out of his own volition. The silent facts of this case are that the claimant was employed by the defendant sometime in 2001, and while serving the first defendant at Econ branch as cash officer, he received a long service award in 2016, and his service with the first defendant has been without any event and cordial. It was cordial until the branch started receiving report of shortages from one of its tellers, Mr. Jeremiah Akpan, and the management of the branch decided to perform integrity test on the staff, on the said staff, which was conducted on the 31st day of January 2018, using a customer of the branch, Mrs. Rose Eba, which the said Mr. Jeremiah failed and was recorded in the integrity register signed by the aides and the claimant. The event was also said to have been captured by CCTV camera of the first defendant. When Mr. Jeremiah Akpan approached its defendant and Mr. Matthew Inyang, the resident control officer, who approached the claimant and informed him that Mr. Jeremiah has pleaded and they should all overlook the action of the teller. However, the claimant referred them to the signing of the integrity register and the need to protect the bank and its customers, and he reneged on the suggestion. According to the claimant, his refusal to accede to the suggestion of the defendant and the resident control officer to overlook the integrity test made Jeremiah Akpan to write to the first defendant that he used to give or pay overages into I'm sorry, counsel. I don't know what is happening to my internet today. Yes, I continue. According to the claimant, his refusal to accede to the suggestion made Mr. Jeremiah Akpan to write petition to the first defendant that he used to give or pay overages into claimant's account, a fact which led to suspension of the claimant for 5 months and consequential advice by the disciplinary committee to resign, which report by the regulation was to be out within 3 months, but the panel made it to extend to 5 months without justification, just to punish the claimant and made him to live on half salary for 3 months and 2 months without any salary. Based on the petition of Mr. Jeremiah Okon, a disciplinary committee was set up where the claimant appeared and all others and all the staff concerned. At the end of the committee recommendation, the committee recommended that the claimant be advised to resign. This suit was instituted by the claimant to challenge the validity of the advice for him to resign, as according to him, he was forced to resign. The claimant stated that when he was advised to resign, he wrote a letter of resignation and submitted, but it was rejected, and he was asked to write another one and remove the words advised to resign, which he did. The first letter that was rejected by the first defendant after its submission was tendered in evidence as Exhibit C11, while the second letter, which was accepted by the first defendant, was tendered and admitted in evidence and marked as Exhibit C9. For the defendant, the claimant was advised to resign, and he voluntarily resigned out of his own volition. He resigned his appointment with the defendant. The letter of resignation was tendered and admitted in evidence as Exhibit D2. This exhibit is same as Exhibit C9 tendered by the claimant. The defendant insisted that the advice for the claimant to resign was done in line with the terms and conditions of service, Exhibit D4 and D17, which are binding on the parties. I quite agree with counsel for the defendant that the terms and conditions of service are binding on parties to a contract of employment, like in this case, and parties are not allowed to go outside the terms and conditions of service, and the court is also bound by the conditions of service in determining or interpreting the rights and obligations of the parties concerned. See the case of Kado versus CBN. See also Amodu versus Amode. See also Yere versus Bendel Pits and Flour Mills Limited. See also Olale Khan versus Management Board UMTH. See also Raji versus Obafemi Awolowo University. See also Ekunola versus CBN. See also Opomu Oil Farm Company Limited versus Serene. See also Iwuchukwu versus Iwizu. And also Umera versus NRC. In view of the position of the law as enunciated in the above cited cases, Exhibit C1, that is the letter of employment of the claimant, Exhibit D4 and Exhibit D7 in this case, which are the staff handbook, which are staff handbook and policy of the first dependent, are binding on the parties, and they form the terms and conditions of the contract. In the case at hand, the first dependent relied heavily on Exhibit D8 and D11 as well as the provisions of Exhibit D4 and D7 in advising the claimant to resign from service. I have earlier on in this judgment found Exhibit D8 and D11 as not having any evidential value or not having been duly executed by the 5 members of the disciplinary committee. In the circumstances, the committee report which was relied and based on which claimant was advised to resign, is a document that is that has no any evidential value and does not command any value before the court. In the circumstances, the basis on which the first dependent invokes the provisions of Exhibit D7 to advise the claimant to resign from service that therefore the basis that is exhibit D8 and D11, which is the basis on which the first dependent advised the claimant to resign, having been found not to have any evidential value. I have also found that exhibit D8 and D11 were non-existent as at the time the decision of the advice to resign was given to the claimant. The position, this therefore means that as at the time the first dependent advised the claimant to resign his appointment or his employment, there was no valid disciplinary report. There was no valid disciplinary report which the first dependent used in advising the claimant to resign from his appointment. Therefore, it means that the advice given to this means that the provisions of Exhibit D7, which grants the first dependent power to advise, cannot be invoked in the absence of the disciplinary committee, as the provisions of Exhibit D7 cannot be invoked in vacuum. It has to be based on factual situation, and the factual situation was not in existence as at the time the advice was given to the defendant, was given to the claimant. This is confirmed by DW1, the only witness of the defendant, when he informed the court under cross-examination that Exhibit D7 was made Exhibit D8, was made when this case was pending before the court. Therefore, it is a document that has been caught by the provisions of Section 83 of the Evidence Act. The position taken by the court is strengthened by Exhibit C7, which communicated purported approval of disengagement of the claimant by the management of the first dependent with effect from 11th day of July 2018. Exhibit C7 presupposes Exhibit C7 presupposes that the claimant had already submitted his letter of resignation to the first defendant because the said exhibit C7 was made or issued on Tuesday, July 10, 2018 at 11:07 p.m. This means that this means that the first defendant was purportedly a receipt of the claimant letter of resignation. However, this position is a fallacy, as the letter of resignation was submitted to the first defendant on 11th of July 2018. See exhibit C9, the letter of resignation, and exhibit C11, the first letter which was written by the claimant for the resignation but was rejected by the defendant. Therefore, as far as the decision as far as the decision for the resignation of the claimant from the service of the first defendant, the defendant has already taken a position as far back as 10th of July 2018. Exhibit C7 is also an evidence to show that all the issues regarding advice for the claimant to resign from his employment was orchestrated by the first defendant, that it has already taken a decision before even receipt of the disciplinary report committee or before the disciplinary committee report was ready. And therefore, the decision to advise was not even based on the disciplinary report committee. To confirm that the claimant did not, this also goes to confirm that the claimant did not resign his appointment voluntarily, as he was directed or advised to resign by the defendant. Therefore, the resignation was not voluntary. It was an involuntary action taken by the claimant to save his head. The receipt of Exhibit C11 by the first defendant, evidenced by the stamp on the letter, is also a clear pointer that claimant did not voluntarily resign. If it is true that the claimant resigned voluntarily from the service of the first defendant, the defendant does not have the power to reject Exhibit 11. Once it is received, as the law is that an employer does not have the power to reject resignation of his employee, as the law is well settled that the parties are free to enter and exit employment relationship. In my view, Exhibit C11 has corroborated the assertion of the claimant that he was forced to resign from the services of the first defendant. From all I have been saying above, the case of the claimant is that of constructive dismissal, and by virtue of such constructive dismissal, this finding has settled the case of the claimant. And it also goes to show that the defendant's insistence of complying with the terms and conditions of service could not be correct, as the defendant flagrantly violated its own rules because as at the time, the decision to advise claimant to resign the purported discipline to purportedly to resign his appointment, the purportedly disciplinary report was non-existent. So the first defendant cannot cannot be said to use or invoke Exhibit D7 and D7, D4 and D7 to have advised the claimant to resign, as that cannot be done in vacuum. The advice is unlawful and illegal. It cannot be sustained. Exhibit C11 is an anticipatory approval that was given by the first defendant before even receipt of the letter of resignation. This clearly shows that due process was not followed by the first defendant in advising the claimant to resign his appointment, to resign his appointment with, with to resign his appointment under the provisions of Exhibit D7. The claimant has also, by his relief, insisted that he is still a staff of the first defendant and entitled to payment of his salaries up to date. The law is well settled that in master and servant relationship, court cannot enforce willing employee on unwilling employer and vice versa. The defendant having a means and intention, having a means intention of liking as per Exhibit 11. This court is still relationship with the first defendant. It is only in cases of statutory employees that such a declaration can be made. In a master and servant relationship, the court does not have the power limited. This court also cannot grant an order for the payment of unpaid salaries, allowances to the claimant as cash officer. That is, this claim or relief is vague and lacks certainty, as there was no quantum claim in respect of these reliefs, and how there was no specification of how the claimant arrived at the quantum to be claimed, or the quantum to be has not made to the court, has not clearly made to the court what he is entitled as his salaries and what is entitled as his allowances. The relief is vague and uncertain, and by the virtue of the decision of the Supreme Court in the case of University of Jos versus Dr. MC Ikoigweoha, this court cannot grant a big and uncertain relief. In the circumstances, it is hereby refused. From all I note that the First defendant case, the first defendant position in this matter was based on the alleged mishandling of overages by the overages by the claimant, more particularly the sum of 3,950, which was said to have been declared by one Ididio to the claimant, and the claimant never remitted such money into the account that was meant to receive those monies. Exhibit C6 tendered by the claimant clearly support tendered by the claimant has acknowledged that yes, the said sum was declared as overages. And the claimant was the one in charge of these overages, and also for the payment of the said overages into the appropriate account of the first defendant. However, he did not pay the said overages declared into the appropriate account of the claimant. This allegation has not been debunked by the claimant. And up to date, the claimant has not answered what has happened to the said 3,950,000 declared as overages, which was given to him by the said Ididion. There is no evidence. The claimant has not adduced any evidence to show what has happened to the said 3,950, which he acknowledged which he acknowledged that it has been declared and was supposed to have been paid into the averages account, which has not been paid at the statement of the said account shows that no any payment of such overages has been made during the time the claimant served as cash officer in Econ branch of the first defendant. This clearly means that the claimant this clearly shows that the claimant has not up to date paid the said 3,950 overages into the appropriate account of the claimant, and this clearly violated the policy of the first defendant. And this is a clear case in which, based on only this dereliction of duty by the claimant, the defendant is entitled to take disciplinary action and also to sanction the first defendant. However, However, the defendant, instead of taking appropriate action of either dismissal or termination, decided to advise the claimant to resign his appointment, which is detrimental to the first defendant and which also cannot serve as deterrent to others who may want to do what the claimant has done in this case. From all I have been saying above, the claimant has succeeded in only showing that his resignation was involuntary, as he was forced to resign from his employment by the first defendant. However, he has also failed to establish to the court that the overages of 3,950 declared by one of the tellers that and was given to him has been properly accounted for the failure to account the said 3,950 averages. The claimant cannot be said to be free from any blame. As I said earlier, according to Arinze versus First Bank of Nigeria, an employee can be disciplined even on the basis of allegation of criminal allegation, like in the case, the allegation that the claimant has combated or used the said 3,950 has not been cleared by the claimant, as he has not produced any evidence to show that he actually accounted for the said 3,950,000. In the circumstances and in view of the decision of the Supreme Court in the case of Arinze versus First Bank of Nigeria, the claimant deserve to be punished for the dereliction of duty or his inaptitude deserve to be punished for refusing to adhere to the policy of the first defendant. It is in evidence that the claimant has been paid all his entitlement. The defendant has stated that has paid all his entitlement. This the claimant has confirmed under cross-examination. So if claimant has collected all his entitlement, he is not entitled to the claim of 10. He is not entitled to the claim of 100 million naira general damages. He is also not entitled to any emolument from the date he was advised to resign. That is in July, 11th of July, 2018 to date, as he claimed in his reliefs. And also he is not entitled to be paid the sum of 24,000 only for physical pain, emotional, as he was found not to have accounted for 3,950, which was entrusted to him as overages to pay into the first defendant account meant for that purposes. From all I have been saying above, this court clearly found that there is the advice of the first defendant to the claimant to resign amount to constructive dismissal. However, the claimant having been found to have retained or not remitted 3,950 overages declared and handed over to him, he cannot be entitled to any claim from the defendant, as the defense defendant is entitled to sanction him for what he has done. In the whole, the claimant has not been able to prove his case to entitle him to special damages. He has also failed to prove that he is entitled to payment for prosecution of this case, as there was nothing before the court apart from 800,000 naira received sender as special damages. Apart from its being pleaded, it has to be proved strictly. There was no strict proof, as 800,000 is not the same with 1,800,000 naira. Before I end this judgment, I need to observe that the first defendant and most of the banks that have provision for advising their staff to resign, by doing that, they are not being firm on taking disciplinary action. There is the need for the banks or the first defendant and all other banks to reconsider their stance in advising their staff to resign from service. As such advice does not serve the purpose for which it was meant, that is deterrence. It is the imposition of appropriate punishment for dereliction of duty or misconduct that can be able to curb excesses of staff and checkmate them. Asking staff to resign will only confound the situation whereby they may be able to even claim damages against the said advice. All in all, the claimant has not been able to prove his case to be entitled to the relief sought. More particularly, the claimant has also failed to prove that he is entitled to damages for purported defamation of his character, as he has not been able to adduce evidence in proof of such. At the end, the case of the claimant failed and same is hereby dismissed.
As the court pleases.
As the court pleases. My Lord, we are grateful for the well-considered judgments. Thank you.
Yes, Registrar, any other matter? Registrar. Okay, thank you, Counsel. We have come to the end of today's sitting.
Thank you, my lord.
Thank you. You are
Thank you very
welcome.
much. Thank you.